Well, thank you, Kirk. And Kirk will be around to answer questions when we get into our question and answer session. And I think that Kirk's story is unfortunately not all of that uncommon. I think uh, my experience in working with family businesses has shown that the concept of a prenup is often presented late in the game, as it's so to speak, in the engagement process, and as Kirk referenced, it can instantly be interpreted as a sign of distrust. So how we talk about the prenups and how they're presented is extremely important, which we'll talk about in a little bit. But before that, I'd like to introduce Michael Berger, who's a partner with Berger and Schatz. And Michael is a divorce attorney and has been on both sides of the equation with prenuptial agreements, and is going to talk to us a little bit about the three different mechanisms that we referenced in the beginning in terms of protecting family stock, and talk about what goes into creating a valid prenuptial agreement. So, Michael?
Okay, good afternoon. My pleasure to be with you today. The first issue we're going to speak to, or I'm going to speak to, relates to the buy-sell situation. And clearly, when you have a closely held corporation, it is imperative when you have other shareholders, whether they're family members or outside family members, it is a reasonable and necessary document to execute between all shareholders. With regard to a marital situation, it is very important because it can avoid a lot of issues that we see day to day in closely held corporations. Number one, if it has and you could switch, Ryan, if you would please, to the next slide. If it sets a value for the stock, and it has some objective basis in doing so, a court will be inclined, in the event of a divorce situation, to either adopt that valuation scheme or at least adhere to it in great measure. Certainly not going to disregard it unless it has been disregarded in the past by the shareholders, or if exceptions have been made to what otherwise was set forth in the buy-sell agreement. One issue, which is the second bullet point that we find a lot of litigation on, relates to the intangible value of a company, the goodwill component of a company. And we're not talking about goodwill for the purpose of accounting. We're talking about goodwill for the purpose of fair market value. And that intangible value can be a source of great debate. It can be a source of huge litigation costs, which can be avoided if you have a buy-sell agreement, which is done quite competently to include the value of the stock being also including the goodwill component. A situation which we also see, and as common as you would think it would be in a buy-sell agreement. I just got involved in a situation that actually had to go to court involving a company that did about $80 million in gross revenues, and the buy-sell agreement didn't spell out with great specificity the fact that the stock could not be transferred to a spouse or a non-family member, etc. That caused tremendous litigation and aggravation for my client, who was the shareholder of this corporation, or one of the shareholders of this corporation, and allowed a judge to take into consideration the concept of actually transferring stock that my client had to his now divorcing spouse. So that is a huge issue that all buy-sell agreements should include, and that is a non-alienation, non-transferability type of situation to spouses or non-family members. Again, depending on who the shareholders are and what you're trying to protect. Also, a situation can occur where a value has been placed on the business and someone may want to receive the money upon a particular event. A buy-sell agreement can sort of handcuff the court to provide for the payout to the, quote, family member and therefore to the spouse, divorcing spouse, on the same basis that the family member could receive his payout, rather than suggesting hypothetically that the family member's interest is worth, let's say, $1 million, and therefore the spouse's interest is worth $500,000. The spouse doesn't receive any stock, but receives a $500,000 judgment, which the spouse is suggesting be paid immediately upon the entry of a divorce. That provision could avoid that kind of payout, and therefore would be a provision that I would highly suggest be included in any buy-sell agreement. Ryan, could you switch to the next slide, please? Clearly, having a buy-sell agreement can also resolve disputes among the family members regarding the fair value of the stock, and as I said before, could be binding not only in litigation between the family members, but as it could be binding as well as a divorce situation. Again, like all other contracts, a court has the ability to look into the four corners of that document to determine, is it really a legitimate agreement? When was it created? What was the consideration? Who was the individual or individuals that wanted the agreement? Has it been consistently utilized in transfers of stock, etc.? So a court is not completely bound by a buy-sell agreement, but if it has all the necessary legal bells and whistles, and it has been consistently utilized in previous transactions, the court will be hard-placed not to adhere to the buy-sell and all of the terms of the buy-sell. Ryan, could you switch to the next slide, please? Clearly, the strongest tool available in a marital situation to protect a family asset is a prenuptial agreement. A prenuptial agreement that's done well, and there's all sorts of different definitions of that, but a very competently done prenuptial agreement that follows the basic ingredients or elements for a valid agreement is absolutely enforceable and is the best insurance anyone can buy for relatively small dollars, so to speak, and to protect what might be, at the time of signing the agreement, a valuable company, even to become a much more valuable company. And an agreement, and I would ask for the next slide, please. A prenuptial agreement, as I said in the first bullet point, are routinely upheld in court. It is very, very difficult, almost impossible to defeat a well-drafted prenuptial agreement. And as it relates to a company, there are so many issues. There's a myriad of issues that a good divorce/matrimonial lawyer can raise with a family business, even if that family business is what they call in the law non-marital, premarital. That doesn't mean that all of the value contained in that premarital, non-marital company are non-marital. But if you have a prenuptial agreement, everything that relates to the company can be excluded, not only to the extent of the awarding of the company, but the value of the company could be excluded from consideration in every regard. So not only can you avoid valuation issues, you can actually avoid having the value of this company taken into consideration in dividing what otherwise would be marital assets. And in matrimonial law, you divide the marital assets of the marital estate in keeping with many different elements, but one of the strongest arguments in the division of the marital estate, because Illinois is not a community property state, it's a, quote, equitable property state, is the value of someone's non-marital assets, and especially a family-owned business. And so if someone has an interest in a family-owned business that is merely being excluded from consideration by a prenuptial agreement in the barest of all, or the most basic ways, that doesn't mean that the value of that individual's interest in that business cannot be included in the division or the percentage of the division of the other marital assets. So there are all sorts of different ways that a qualified matrimonial lawyer working independently as well as with corporate lawyers can draft corporate and prenuptial agreements to insulate an individual from the kind of aggravation, not only emotional aggravation, but financial aggravation that could happen in the event of a divorce. And as I said before, it really doesn't take much to create a valid prenuptial agreement. The issue is how good is the agreement? Let's go to the next slide if we can. As I said a moment ago, a poorly drafted prenuptial agreement can be challenged in court if it has the basic elements, and those elements are a document being essentially executed voluntarily. It helps when the other side has a lawyer representing them. It's not a condition that has to be met, but it's always better for a fiancé, for both intended married people to have their own independent lawyers, and I mean independent. It's not good to have your, quote, corporate or family lawyer referring your fiancé to a lawyer that they've done business with or they know, etc. But a completely independent lawyer. The agreement has to be entered into voluntarily, and then there has to be a disclosure, a financial disclosure. It can be waived, but there has to be a written waiver